Here's a question I want you to sit with for a moment. If you pay money directly to someone who is not your employee, someone who is employed, let's say, by the government, or someone whose salary is paid by another person, so that means their pay is already deducted by someone else. If you're making any payment to them, are you required to deduct pay from that payment? KRA said yes, but the High Court said no. And the reasoning for KRA to say yes and the High Court to say no, it's something that every business owner in Kenya that makes payments to other people should be able to understand. And the reason matters for every business in Kenya that makes payment to people it does not employ. Here's the thing. We all know that pay as you earn, it's an obligation that sits with the employer. But what happens when the same individual receives payment from two different sources? So they receive payment from their employer and an additional payment from a third party who is responsible for deducting pay as you earn. According to KRA, you are responsible. KRA's position in this case was that the person making payment, regardless of whether they are the employer, is responsible for deducting pay as you earn. The High Court found that this reading would require rewriting the law, and that is the job for Parliament, and that is not the job for the courts. And let me tell you why. The project that is at the center of this dispute is a project that you already know, and this is the SGR. Now, China Road and Bridge Corporation, which is the company that was building the SGR, wanted security provided for its sites. So, the Kenya Railways Police Unit provided security officers to guard the construction site. Zile matrakta. Unaona mahali kuna mogo mchanga kuna tractor. So, the police unit provided security for that. Now, China Road and Bridge Corporation provided the officers with different allowances. They give them overtime, they give them some subsistence, pesa kidogo, and these rates were directly set by the National Police Service. And the National Police Service continued to pay the officers their salaries and they deducted pay from those salaries. But you see, China Road and Bridge paid the other allowances directly to the police officers. That is why KRA came to CRBC and demanded 64 million shillings in unpaid pay, which according to KRA should have been paid on the allowances that these police officers had been getting. CRBC on its end said they were not the employer. Now, by the end of this video, you are going to understand exactly what triggered that pay obligation and under Kenyan law, why the employer-employee relationship is very, very key. And at the end, I'll let you know what practical implications for you as a business person in case you are making payments directly to people that are employed by third parties. In the year 2013, as Uhuru and Ruto were wearing matching outfits, matching shirts, and matching ties, China Road and Bridge Corporation won the contract to build the SGR. This was being built from Nairobi to Mombasa, or from Mombasa to Nairobi. Anyway, now, security for this project was a very serious concern. The contract between CRBC and Kenya Railways stated that the Kenyan government would provide all the security that is needed, but CRBC will be paying the cost for that security. In the year 2014, as corruption to compensate landowners affected by the SGR was ongoing, CRBC, Kenya Railways, and the National Police Service held a meeting. During this meeting, they agreed that Kenya Railways Police Unit would deploy officers to guard the SGR construction sites. And the minutes from that meeting were very clear. The deployed officers would remain members of the National Police Service, which means their terms of employment would stay within the NPS, National Police Service. And because of this, the NPS had full control over who gets hired, who gets assigned to the sites, who gets transferred, in case of a misconduct, how disciplining was going to be done, and in case one needed to be fired, who is going to be fired. CRBC's role was only to pay certain allowances, overtime, and subsistence, and this they will pay directly to the officers using rates that had been given to them by the National Police Service. The officers' normal salaries would continue to be paid by the NPS because the NPS already had their payroll records. So NPS would deduct pay from all those salaries and remit that to KRA. And this arrangement worked without any problem, and this went on for several years. But whenever things are going too well, you can be sure of one thing, that someone is going to come in and spoil the party. And someone did. In the year 2017, KRA investigated CRBC's tax records, and they did this for the year 2014, 2015, and 2016. When they looked at these records, they decided that the allowances that were being paid to the police officers, these were gains or profit from employment, and thus they should be subjected to paying. And the demand wasn't literal. The demand was 64 million, and this included, as usual, penalties and interest. This is a huge amount. And CRBC objected to KRA, arguing that CRBC was not the employer, that the National Police Service remained the employer. KRA was unshaken. They went ahead and confirmed the assessment. Now, CRBC, armed with a lot of conviction, appealed to the Tax Appeals Tribunal. And the tribunal, as a good judge is, cleared the ring. They put KRA in the red corner and they put CRBC in the blue corner. And the two parties went at each other with all that they had. And the fight between these two titans was brutal. Each gave as good as they got. And once all of them were tired from the fight, the tribunal gave its decision. When both parties lay on the floor, breathless, the tribunal, as a good referee, stepped in. The Tax Appeal Tribunal agreed with CRBC on one major point. They agreed that there was no employer-employee relationship between CRBC and the police officers. The tribunal noted that such a relationship would have been impossible because police officers can only be employed by the National Police Service. But the tribunal made an argument that went further than the law. It said that the duty to deduct pay is triggered not by this employer-employee relationship, but by control over payment and control over the payment amount. CRBC on its end had chosen to pay the officers directly rather than routing the money through the NPS payroll. By choosing to pay the directly, according to the tribunal, CRBC had assumed the payee obligation. And because of this reason, the assessment was upheld. CRBC felt that the referee had been very fair during the match, but the referee had selected the boxer who was half beaten to death. They therefore requested the High Court for a rematch. Now, the High Court agreed. The fight then continued in a different arena. And as usual, CRBC continued landing heavy and heavy punches to KRA. But KRA as well wasn't to take it lying down. KRA trying to duck, but some good punches landed and they landed where they should have. And the judge, fearing a total collapse, came in. Justice Majanja applied a principle that sits at the heart of all tax law, and that is tax statutes must be read strictly and according to their plain words. You cannot add meaning that Parliament did not put there. So the judge looked at section 37(1) of the Income Tax Act, and this says that an employer who is paying any emoluments to an employee shall deduct pay. And according to the judge, both words matter, employer and employee. If you are not the employer, then the obligation to deduct pay as you earn does not arise regardless of who is making that payment. The judge also identified a problem with the tribunal's reasoning. CRBC had no access to the police officers' payroll records or their income from different sources. They didn't have records of their personal relief details or any information that they would have used to calculate their correct pay liability. Because only the National Police Service, as their true employer, had the full knowledge of each of the officers' tax position, and therefore only the NPS could accurately calculate and deduct the correct tax amount. Therefore, requiring CRBC to guess the pay calculations for people it did not employ because employed by the NPS, it would be very impractical and very unfair. And that is why the High Court allowed the appeal. And because of that, the 64 million demand from KRA was cancelled. KRA sat down, picked its clothes, and walked away. Not carried in a review. At least we live to fight another day. And that win was a win for you too. If you're a business that makes payments directly to individuals who are employed by a third party. Let's say these are staff that have been seconded to you by a separate contractor. The payee obligation in respect for any payments that you are making does not rest with you. What matters is who has the power to one, the power to hire, the power to direct, the power to discipline, and finally, the power to dismiss the individual. The one who has that power is where the obligation lies. However, if you're making payments to individuals who are genuinely providing business services to you, that may not be an employment relationship, but it could be something else. Like if you're paying commissions, that's different. Or they could be consultants, and for them, you have a different tax obligation, and that is withholding tax on any service fee that you're paying. The difference between an employed person receiving allowances and an independent service provider who is receiving fees matters a lot because it decides how the tax is calculated and who is ultimately responsible for deducting that tax. If your business has an arrangement where you pay people who are not on your payroll and you are unsure whether the payments would trigger pay or withholding tax, reach out to us because getting this clarification right is very important before KRA audits you and hits you with a heavy penalty. Getting this clarification right before KRA audits you is significantly less expensive than fighting KRA afterwards. In the next video, I'm going to tell you a Nairobi property company that received a 76 million tax demand. The case turned into something called the banking test. And the High Court ruling on when KRA can use that test is something that every landlord in Kenya should understand. So go ahead and watch that video next.